Mr. Davis, can you hear me?
Yes, I can, Your Honor, perfectly.
Thank you. I have, I'm going to guess, well, I have a Molly Slade. Who is Molly Slade and what is your relation to my calendar today?
I hope that translates into Curtis Jones.
Yes, I'm sorry, it does. And I'm sorry if our camera isn't working. I'm trying to figure that one out. But Curtis is right here with me.
Okay. We will go on the record in the matter 25 CF 134, State of Wisconsin versus John Auberg. The state appears through District Attorney Kevin Schmidt in person. Mr. Auberg appears in person with counsel Nicholas Davis by video conferencing. We're set today in this matter for a status conference. Mr. Davis, please update the court.
Your Honor, at this time, the case is not resolved, but it's because I'm having difficulty getting information with regard to his collateral attack. And it may be like the State v. Clark, where I'm going to have to file the motion. If the records don't exist, I understand the burden of proof will be on me, and it doesn't shift to the state unless I show with evidence that it should shift on the state to show that he was not guaranteed his constitutional rights. So if the court can allow, I can certainly file a motion to do such a thing. And if you want me to file a motion first, then set a motion date, or set the motion date now, the court can tell me what to do.
Please file the motion and then you'll get a motion date. I can give you a status right now, but hopefully you can have that motion filed prior to returning.
Yes, Your Honor.
Can you do March 23rd at 9:45?
I cannot do that date.
That's fine. Okay. How about March 9th at 2?
Yes, Judge, I can do that.
All right, March 9th at 2 p.m.
Wait, I'm sorry, Judge. I just looked. I have a jury trial in Hudson that day.
All right, let's not do that then. What about March 13th at 10:30?
I have a final pretrial at 10:30, but I can do before or after that.
11?
Yes, I'll be available.
March 13th at 11.
And I'll try and get that filed right away, Judge.
If you get that filed in the next 2 weeks, we can convert it to a motion hearing.
Yes, Your Honor.
All right, thank you.
John's address is the same, phone number is the same, everything is the same with John.
All right, thank you. Then we are adjourned. You can come get your notice. So set it for a half hour, just because it may be converted. I trust he'll get his motion filed.
Skip ahead if you don't want narration. The original video continues after this. Welcome back, everyone. Today, we've got a courtroom roller coaster featuring multiple defendants, video conferencing surprises, and some tense back and forth over fines, motions, and plea deals. Stick around as we break down exactly what's happening in the cases of Curtis Jones, John Auberg, and more. Who's facing jail time, who's walking away, and which legal twists could have massive consequences. You won't want to miss a second.
We will go on the record in the matter 21 CF 122, State of Wisconsin versus Curtis Jones. The state appears through District Attorney Kevin Schmidt in person. Mr. Jones appears by video conferencing capability. His attorney, Nicholas Davis, appears by video conference. We're set today in this matter for a status conference. Mr. Davis, can you please update the court?
Your Honor, the case is resolved, and I believe Curtis will acknowledge that. My understanding would resolve with a plea to a disorderly conduct with cost disposition.
And time served, did he sit any time in jail?
That's what the offer was, and I believe he'll accept it.
Is that accurate, Mr. Jones?
Yep.
You wish to accept the offer of disorderly conduct for fines only?
Yep.
And I don't know how much time, but it would be time served. I don't know how much time he said, Judge. I just don't.
All right, we don't have any cash left because this is so old on the warrant. But I'm prepared to move forward and get the plea. But Mr. Jones, there will be $443 in fines and fees if the court does accept the agreement, and that's going to need to be paid. Otherwise, the court will issue another warrant and you could sit up to 6 months in jail. Do you understand that?
Yes.
All right, and that's the offer from the state plea to the DC
Yes.
without the domestic abuse.
Yes.
Formal motion to amend to remove.
So made.
Granted. All right, Mr. Jones, how old are you?
I am 45, just turned 45.
Can you read, write? Do you understand the English language?
Yep.
Any drugs, alcohol, or other medications in the last 24 hours?
Nope.
Any mental illnesses or disorders?
Nope.
Do you understand that you have certain constitutional rights because you were charged with crimes? That is, you would have the right to a jury. You would have the right to have your attorney cross-examine the state's witnesses or call witnesses to testify for you. You would have the right to testify on your own behalf or remain silent and not have your silence used against you. You would also have the right to have that jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty verdict or find you not guilty. And you would also have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand all those rights that you're giving up here today?
Yes.
And do you understand you're pleading guilty to to a crime by video conferencing capability? Do you understand that you have the right to be here in person?
Yes.
And are you asking the court to allow or to waive that right so that you may appear by video conferencing to enter your plea and to be sentenced?
Yes.
If at any time you have any questions or concerns and you need to speak with your attorney, let me know and I'll send you into a confidential breakout session, okay?
Okay. Thank you.
Here's where it gets really interesting. Curtis Jones is pleading guilty to disorderly conduct, but notice how carefully the court goes through all of his constitutional rights. From jury trials to cross-examining witnesses, he's giving up major protections just to resolve an old case. This is a textbook example of how even seemingly minor charges carry serious legal weight, and it raises the question, would you risk giving up those rights to avoid more time or fines? Also, $443 in fines and fees isn't just paperwork, it's real consequences if unpaid.
Do you understand that the state would have, first off, let's backtrack. Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
You understand the state would have to
Yeah.
prove on or around April 16th, 2021 in Burnett County, Wisconsin, in a public place, you engaged in indecent, unreasonably loud, boisterous, or otherwise disorderly conduct, which tended to provoke a disturbance. Do you understand what the state would have to prove?
Yes.
Do you understand the maximum possible penalty could be a fine of up to $1,000 or imprisonment of up to 90 days or both?
Yes.
Do you understand that there is an agreement here for costs only, but I'm not bound to follow that? Do you understand that?
Yes.
Said differently, I could sentence you to the maximum possible penalty if I thought it was warranted. Do you understand that?
Yes.
Do you still wish to proceed and enter a guilty plea?
Yes.
Did you go over the criminal complaint, the facts alleged in this case with your attorney, the basis for these criminal charges?
Yes.
For the most part, are they accurate?
Yes.
Did you engage in either indecent, unreasonably loud, or boisterous behavior?
Yes.
Did it provoke a disturbance?
Yes.
Mr. Davis, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or any promises to you, Mr. Jones, for you to plead guilty to this charge? You're doing so freely
Yep.
and intelligently, telling me you fully understand what you're doing
Yep.
and voluntarily.
Yep.
Has your attorney represented you competently?
Yep.
Has he answered all of your questions?
Yes.
Has he looked at this matter thoroughly?
Yeah.
Are you satisfied with his services?
Yes.
Have any questions for the court or for your attorney before I proceed?
No.
Then as to count 2, straight disorderly conduct, how do you wish to plead?
Guilty.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea. Judgment of conviction will be entered. Argument, Mr. Schmidt.
This is a minor DC. This is a defendant with minor misdemeanor history from 2012 and 2013, so very long ago. As the court recalls, the co-defendant's case went a lot faster, and I dismissed the felony at the prelim because there was never very good evidence of it. I would have done this, but we just never even got to the prelim point. So I think this is appropriate. Thank you.
Thank you. Mr. Davis?
I join in with what the state has said, Your Honor.
All right. Well, this is not the most serious matter. The court, if I look at the victim here and the underlying facts, I remember and I recall the incident and what occurred. And quite honestly, the original offer that was received way back in 2021. You're pleading guilty, you're admitting to a crime. So I'm thinking that costs are appropriate here. Again, this is a very old case and they're just getting it resolved. I will assess $443 in fines, fees, DNA surcharge, etc. Mr. Jones, can you have that paid within 30 days?
Yes.
Okay, failure to pay within 30 days means the court will enter a civil judgment against you, and I will issue a warrant. You could sit up to 6 months in jail. Do you understand that?
Yes.
Is your address P.O. Box 2263, Inver Grove Heights?
Yep.
Telephone ends in 5904.
Yep.
All right. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I need to order your DNA. You need to call the Burnett County Sheriff's Department and see if they need it. If they need it, then you must make arrangements to get them a DNA sample within 60 days. You have the ability to request it be expunged through the system through a written letter to the Department of Justice, not to this court, to the Department of Justice. The other charges are dismissed and read in. I believe that covers everything, Mr. Schmidt.
Nothing for me.
Mr. Davis?
Nothing further, Your Honor. Thank you very much.
Thank you. Then we are adjourned.
Thank you.
Thank you.
Thank you.
All right, we will go on the record in the matter 25 CM67, State of Wisconsin versus Zachary Rawls. The state appears through District Attorney Kevin Schmidt in person. Mr. Rawls doesn't appear. We're set today in this matter for a status conference. He was to do an anger management with Dave Hatch, Restorative Justice. He did not need to appear if he completed the program. Any confirmation that he's completed the program? Did he provide proof to you, Mr. Schmidt? I don't have anything in my file.
I don't have anything either. I'm just checking my emails. I want to make sure Dave didn't email me or anything.
Usually Mr. Hatch emails, I don't know if he emails you and copies the court or whatnot, but if he does email, he does let the court know that somebody's completed and that's put in the electronic file, but I don't have it in this case.
And he usually doesn't email me, but I just want to be double sure. Just to be safe. No, I haven't gotten anything about that.
And I haven't either. And Mr. Rawls was given permission to not appear if he did complete the program, and there was proof of that. We do not have proof of that. What is the state requesting?
I'd ask for a warrant.
Trying to find how much he is paid. $500 and then $150 went. Thank you. Because he hasn't shown proof that he's completed the program and he fails to appear, the court is going to issue a warrant. I'm going to issue the warrant with an additional $150 cash. Only judge may quash or posting of the cash. He will be provided a new date and time upon posting. The court is going to forfeit the cash previously posted. It was $500 minus $150 that was directed to be paid to Dave Hatch to cover the program. If the court gets proof that his failure to appear here today was not through his own, or if he was just confused, the court may set aside the forfeiture, but at least at this time, the cash is forfeited.
Now, here's the drama turning up the heat. Zachary Rolls didn't show proof of completing his anger management program, which means the court is issuing a warrant and forfeiting part of the cash he already posted. It's a perfect example of how procedural compliance, something as simple as sending an email, can become a game changer in court. The stakes here aren't just financial. Failure to follow through could land him in jail. It's a wake-up call about how even small missteps can escalate quickly in legal proceedings.
We are adjourned.
And I did email Dave Hatch. If he tells me he did do it and just forgot to tell us, I'll let the court know.
Thank you. All right, Mr. Lindemann. We will go on the record in the matter 25 CM 240, State of Wisconsin versus Gage Lindemann. The state appears through District Attorney Kevin Schmidt in person. Mr. Lindemann appears in person. His counsel, Amber Sherwood, by video conferencing with approval of the court. We're set here today in this matter for a status conference. Before I begin, Mr. Lindemann, is your mailing address 24986 St. Croix Street?
Eagle Feather Drive.
So it's 24986 Eagle Feather?
Yes.
And is it Webster or Danbury?
Webster, Wisconsin.
Webster. Telephone ends in 2609.
No.
Can I get an updated?
715-416-4872.
May we send you text message notifications?
Yes.
All right, thank you. Ms. Sherwood, please update the court.
Yes, Your Honor. It does appear Mr. Lindemann has finished the anger management course. Dave Hatch has placed that in the e-file. We have an offer from the state that when that was completed, it would be dismissed. I had confirmation from ADA Vila at this time.
All right.
And I'd be victim rights compliant to just do that right now.
Okay. So formal motion to amend.
So made, and this is based upon him completing the course domestic violence class. We're victim rights compliant.
All right. How does he wish to plead?
We're dismissing it.
Oh, you're dismissing it. Sorry.
Yeah.
That's right. I was sorry. I was looking at if we have cash paid and all of that other stuff. So my mind wasn't really focused on what was happening. Okay. So you're dismissing it. And I believe he has $250 posted. And did we send any money to Mr. Hatch?
I paid my own. I had to pay an extra $152.
Excellent. Thank you. So it is dismissed. And you should be getting the money that you have here in the court file. It should be sent back to you or whomever posted it.
Okay.
Okay?
Yep.
All right. Thank you. Then we are adjourned. Good job, Mr. Lindemann.
Thank you, Your Honor. Have a good day.
You too. Mr. Ritchie? Yes, because his case actually has the notation from Mr. Hatch that he's completed. So usually he does that. So it's Mr. Rawls. I'm not sure where we are. We will go on the record in the matter 25 CM 100, 25 CM 134, 25 TR 478, 479, 521, 522, 523, 524, 525, 526, 527, 678, and 679. State of Wisconsin, County of Burnett versus Ronald Ritchie. The state appears through District Attorney Kevin Schmidt in person. Mr. Ritchie appears in person with counsel Amber Sherwood by video conferencing. We're set today in this matter for status conferences. Ms. Sherwood, where is he in the process of getting his license?
Your Honor, I'm unaware at the moment. Mr. Ritchie, were you able to obtain your license?
So I passed the driving test and all
The
that.
microphone a little bit closer.
I passed the driving test about a week ago, but I didn't have enough cash to pay for the actual driver's license. It
How much is that?
was $75.
And when do you think you'll be able to do that?
I'm kind of hoping today or tomorrow.
Excellent. Okay, that would be great. And then, so once he gets his driver's license, then is it amend to a THC ordinance or is it plead to a THC?
It was amend to a THC ordinance, Your Honor.
All right. So once you get your driver's license, Mr. Ritchie, and you get a copy of that to your attorney so she can provide it to the state, unless she's okay with you actually bringing the copy to the state yourself, you wouldn't need to come back to court because it can just be taken care of by paper. Okay?
Yeah, I didn't realize until after I had left that day that I could have got a paper copy of the driver's license. It was just the card that costed $75.
Hopefully you can take care of that soon.
Yeah.
He has $250 posted. I believe that's all that I am seeing anyway.
That's all I'm aware of, Your Honor.
Okay. And so, Mr. Schmidt, if this is done by paper, the court would be satisfied with the ordinance violation fee of $250.
Okay. So as in, that's enough to cover costs and fees.
Correct. All right. So once you get your license and you have a copy, bring it to the state. If your attorney's okay with that, or give it to her so she can bring it to the state. Okay.
Okay.
All right. And then you wouldn't need to come back. I'm going to set another date and time just to make sure that we don't lose you in the mix. Miss Sherwood, can you do March 12th at 10?
Yes, Your Honor.
So March 12th at 10 a.m. Okay, so if you haven't done that already, then you do need to come to court. But if you do all of that, you don't need to come back to court.
If I bring it here, where would I bring it to? Just
To his office, to
Where's
the
that at?
district attorney's office. It's almost all the way down the hall. When you turn out here and you walk all the way down, it's on your right.
okay.
It's not the far end, but it's close to.
Gotcha.
Okay. All right. Thank you. Then we are adjourned. Come and get your notice.
Thank you. And Mr. Ritchie, do you have an updated number for me?
It's still currently turned off.
Okay.
Okay.
Thank you.
All right. Thank you.
All right, let's wrap this up. Today we saw cases ranging from minor disorderly conduct to procedural missteps with anger management programs, highlighting the nuances of video court appearances, plea deals, and the importance of following every court order. Defendants like Curtis Jones accepted fines and time served, while others, like Zachary Rawls, faced immediate consequences for failing to comply. These cases remind us that the legal system isn't just about punishment, it's about accountability, timing, and understanding your rights. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.